one victory opens the door. Once you kick that door open, it opens many other doors. I'm here tonight because of the United States Supreme Court decision in Miller versus Alabama that released hundreds of people who were condemned to die in prison as juveniles, as children. That decision opened the door for the commutation process, in which we saw over 50 people serving death by incarceration be granted commutation when commutation was shut down for decades. Now, although we have suffered some setbacks with the current administration under Shapiro, who has backtracked on commutations, I'm making that point just to show that our battle to end death by incarceration and dismantle this system is an incremental battle. It is like the African saying, how do you eat an elephant? One bite at a time. And that has been our strategy all along when it comes to abolishing death by incarceration. And tonight, I really want to lift up the movement that made this possible. And I'm talking about the movement that goes back to the 1970s, 1960s. I'm talking about people like Lois Richardson. I'm talking people like Dr. William Goldsby, the original Fight for Lifers crew, the Incarcerated Citizens Coalition, and the many other nameless and faceless individuals that for decades have been fighting against this unjust sentence. I'm shouting out the Human Rights Coalition that really gave birth to this modern abolitionist movement that we have in Pennsylvania. Decarcerate PA, CADB, Amnesty Law Project, and the Abolitionist Law Center. Yes, the death penalty need to be abolished. When I say abolish and dismantle this carceral state, I'm talking about all state violence, all sentences that treat human beings disposable. And there's many other people that I've not named, many other organizations, but I am naming some of our folks that have been here on the ground with us from the 90s. Like, this is for y'all. This is for the people that was in the prisons in the 60s and 70s and 80s who suffered in solitary confinement with us, who suffered back when there was no movement, who went to those meetings in North Philadelphia when Dr. Goldsby kicked off Fight for Lifers in 1991. So listen, there's accolades to be shouted throughout this ecosystem for every organization, whether it's FAMM, Prison Society, everyone. But I do want to lift up the foundation that was laid through the Human Rights Coalition, Fight for Lifers, because that is where this modern abolitionist movement in Pennsylvania emerged from, specifically the folks that are on this call and have helped make this decision possible and been at the forefront of it. But I also want to thank each and every one of you tonight, because I'll tell you why. It is going to be each and every one of us here tonight that implements the lead decision. It is going to be each and every one of us here tonight that makes sure that we take this decision and we ram it through the doors of the carceral state in order to free not just people who are serving second-degree murder, but to build off of this so that we could free people who are serving first-degree murder. And we could build off it to people who are serving terminal sentences, sentences that condemn them to spend the rest of their life in prison, people that are serving the death sentence, all people who are trapped in the carceral state. We're going to use this decision. This decision, like the Miller v. Alabama, is the tip of our spear to end the carceral state. So I just wanted to ground us in that, where we're at tonight, that we are here to finish the job. You're going to hear from Brett Grody, our legal director. You're going to hear from Roxanne Harrell, our legislative director, FAMM trustee from FAMM. You're going to hear from John Rowland, Sean Damon, and I may be forgetting someone, but I apologize. But this here tonight is for us. This here tonight is for us to get prepared for the battle that is going to be ahead of us, to liberate our loved ones in prison, our sons, our daughters, our brothers, our cousins, our comrades, our mothers, our fathers, cousins, our community. Someone dropped that it takes a community. It does. It takes a community to liberate our people. And I want to give everyone their flowers, everyone their accolades. Brett, who argued the case in front of the PA Supreme Court and won. But let me say something to you. Someone out there, if you just sent an email to help this movement, if you just sent a letter to help this movement, if you just attended a protest to help this movement, if you just picked up that phone call to call a legislator or prison to help this movement, I want you to know that we appreciate you just as much, because we're all in this together. And so I'm going to pass this off to my comrades, and I want to lift up everyone again in this movement. Thank you for helping make this happen.
Yeah, Wispy, can you just go through, I guess, what we'll be talking about today, and then we'll pass it on to Brett to talk about the case.
Absolutely. Hey all, my name is Sean Damon. I'm the Director of Strategic Partnerships at Straight Ahead, and my work centers on legislative advocacy to pass second chance legislation. I was asked to sort of set the stage and preview what we'll be getting into tonight. As Saleem underscored, this is a massive victory, but we all have a lot of questions. So tonight we're going to explore the information we have on hand together so we can get more clarity about what the path ahead might look like. We'll start off by hearing from the lawyers who successfully argued this case, Brett Grote and Quinn Cousins. They'll be able to
Brett
break
Good and
they'll
Gwen
be able to
Cousins.
break down the decision for us and tell us what it means for our friends and for our loved ones who are serving unconstitutional death by incarceration sentences for second degree. Then we'll hear from Roxanne, Celeste Trusty from FAMM, and myself about the legislative landscape. We'll talk about legislation that is starting to move that could immediately create a pathway home for hundreds. And we will talk about why it's important for all of us to be involved in pressing decision makers to do the right thing and the importance of building a united front to get this done. Finally, we will close this out by hearing from John Rowland, the campaigns manager at Abolitionist Law Center, and myself about next steps and practical things we can do. And then we'll move to question and answer. We have a packed agenda for tonight. So let's dive in, and I'm going to kick this over to the folks on legal. I know you all are on mute right now, but let's give a big round of applause in the chat for Brett and Quinn.
Yeah. Quinn, can you turn your camera on so I can spotlight you?
It should be on.
Okay, our turn. All right, really excited to be here with everybody. See so many familiar faces and so many familiar names, and people who have been in this struggle, been inspiring us for a long time in order to be contributing to the legal arm, the legal liberation front of our decarceral and abolitionist movement here in Pennsylvania. Before getting into some of the substance of the ruling, I was just doing an interview with a reporter and they were asking why Derek Lee and why his case was the one that went up to the Pennsylvania Supreme Court. And I won't get into all the nuance of it, but it came organically because we have been at the Abolitionist Law Center, but before the Abolitionist Law Center, when I was working with the Human Rights Coalition, after Saleem and Etta recruited me into that organization, we've been embedded with this community of people that are serving death by incarceration sentences, of their family members, of movement organizations. And Derek Lee reached out to us because he knew that Quinn and I and ALC were trying to challenge life without parole sentences. We understood that as our mission from our comrades on the inside, whose advocacy was critical to the formation of the coalition to abolish death by incarceration around 2015, that these types of sentences should be a strategic priority for those of us on the outside. And going back to 2016, when we first filed a challenge to a life without parole sentence for Avis Lee, who's here with us tonight now, to Charmaine Fender, who needs to be out here with us, and to Chet Away. I don't know if he's here with us, but he is out here free now. Those were our first challenges when we had an opening under Montgomery to argue that Miller should be extended to those who are 18, right? To try to press the law. And up until Thursday, we've had 10 years of what would appear to have been defeats, challenging life without parole sentences, but we can now see we're testing grounds where we were sharpening our strategy and building our forces. And Derek encountered us during that testing period when Quinn and I were at SCI Smithfield, invited by the Lifers Association to talk about litigation challenges to death by incarceration. Derek's mother attended CADB meetings in Pittsburgh. So Derek knew to reach out to us when his appellate rights got reinstated. And he did that, and we had a direct appeal, and we were able to go up on the merits of the issue, not have to deal with the Post-Conviction Relief Act and any of these time bars. And we had a clean shot at the constitutional ruling. But it wasn't just legal arguments that won the case. Far from it. This was one strategic initiative out of many that included commutation reform, fighting on the legislative front, community organizing, building power inside the prison and in our communities. And so when Derek went to the Pennsylvania Supreme Court, he didn't go by himself. There were 16 amicus briefs. Was it 16 or 17, Quinn? I think it was 16. He's growing in my mind. There were 16 amicus briefs, and for some context, I'm not aware of any single case in Pennsylvania about any issue, at least in modern history, that has had that many amicus briefs in support. Not any criminal case for sure. Certainly not any case dealing with homicide offenses. That is a testament to years, and as Salim invoked, decades of organizing. And they had amicus briefs that included testimony from people who had served life without parole sentences and who had been released through commutation or resentencing, going back to the courts and advocating for the people that they left behind. There were amicus briefs from people who had lost loved ones to violence and lost loved ones to death by incarceration, speaking out about the importance of allowing a pathway home. There were amicus briefs highlighting international human rights law and the work to create a right to redemption. That was very much a product of our movements and the Right to Redemption organization, SCI Greaterford. So it was our whole movement that went to the court, and those amicus briefs showed the breadth of support and also considerable political cover for the court. It took them so long to issue this decision because they understood how monumental it was. So when they did issue this decision, what did they decide? Let's get into that. So in Derek Lee's case, he was convicted of participating in a home invasion robbery. And when he was upstairs during the robbery and his co-defendant and two individuals who were held up at gunpoint were downstairs, there was a struggle over the weapon. The gun went off, resulting in the death of the victim. And because Mr. Lee was convicted of participating in the robbery, he was convicted of second-degree murder. So the court struck down his sentence. They've reversed the case to the Court of Common Pleas of Allegheny County in order that he be resentenced. They struck down the mandatory life without parole sentence. Well, first I want to say they emphasized that they did not strike, that they were accepting this as a facial challenge. So a facial challenge in the law is a challenge to a statute based on the text of the statute. This is distinct from what's called an as-applied challenge. As-applied would argue this statute is constitutional, but when you apply it, say, to somebody who didn't take somebody's life, that would be a version of an as-applied challenge. If you apply it to somebody who was the getaway driver, then it's excessive. So what does it mean that they accepted this as a facial challenge? It meant that the Pennsylvania Supreme Court was considering the constitutionality of mandatory life without parole for the crime of felony murder, regardless of the facts of any felony murder or second-degree murder conviction. This is important because when they struck down mandatory life without parole, it was emphasized in the opinion that all mandatory life without parole sentences for second-degree murder are unconstitutional. Now, it said they were unconstitutional under the state constitution. This is also important. The movement to abolish death by incarceration in Pennsylvania has just brought to life a dormant constitutional right, a constitutional right that has not existed in Pennsylvania before. And that is Article 1, Section 13 of the state constitution, which prohibits cruel punishments. Now, this is different text from the federal constitution's 8th Amendment, which prohibits cruel and unusual punishments. The state constitution prohibition against cruel punishments has been on the books since 1790, but not until Thursday, not until the case that has been the culmination and also a new launch point for this movement has that right been given any independent meaning. This is the first case, in which the Pennsylvania Supreme Court has said the cruel punishment clause of the state constitution has independent meaning and it provides greater protection than the federal constitution's Eighth Amendment. In the context of second-degree murder, the court found that mandatory life without parole is excessive because it sweeps in too great a breadth of conduct. We had argued that life without parole for second-degree murder should be unconstitutional in all situations, whether it's mandatory or not. We thought that might be too far for the court. They wouldn't go that far, and they didn't go that far. But they did state very clearly that a mandatory life without parole sentence is unconstitutional. And since everybody who's currently convicted of second-degree murder was sentenced under this mandatory sentencing scheme, that means everybody's sentence is unconstitutional. In this sense, it's very similar to the Supreme Court's ruling in Miller v. Alabama in 2012, which struck down mandatory life without parole for people that were younger than 18, right? It said it poses too great a risk of disproportionate sentencing, disproportionate punishment, and that's because it does not take into account individual culpability or somebody's blameworthiness. So what does that mean, and what are the limits on the decision? It only touches the mandatory aspect right now. So that means life without parole is still a constitutionally permissible sentence for second-degree murder. At Derek's resentencing proceeding, he can be sentenced to life with parole, without parole, but only after an individualized consideration that has life with parole as an option. The decision also only applies to Derek Lee right now. It also would, as a legal matter, apply to any other case that's currently on direct appeal or any case that arises in the future. The court explicitly said they did not have to decide the retroactivity question, so they weren't going to decide it. That doesn't mean that it isn't retroactive. It just means they didn't issue a determination as to whether it's retroactive. And to break that down, a case is considered retroactive, a case would be considered in need of retroactive relief if the case is considered completed, meaning it has gone through the trial court and then up the chain to the Superior Court on direct appeal, the PA Supreme Court, the U.S. Supreme Court. After that, you can still appeal a conviction or a sentence. In Pennsylvania, you have to do that through a Post-Conviction Relief Act petition or a PCRA. So in order to get a ruling that it applies retroactively, somebody would have to argue that this new constitutional right does apply retroactively. The court also issued a 120-day stay on the ruling. So a stay is just a word for a pause. Derek is to be resentenced, but they stayed the ruling to allow the legislature a time, not an indefinite period of time, but some time to create a remedy. The court did indicate what would happen if the legislature did not pass a law that would say what comes next. That Derek would be resentenced, that the court would be permitted to impose life with parole or life without parole. And if it's life with parole, the court will have discretion to set a minimum sentence. And for those who are familiar with how retroactive juvenile life without parole cases were treated in Pennsylvania after the Supreme Court held in 2016 that Miller v. Alabama applied retroactively, it's the same proceeding that happened for those cases. That's what would follow for Derek's case. And now if the legislature does not pass a bill, or if they do not pass a bill that applies retroactively, then that means it will be our task and others, who lawyers in this area and the people we represent to get a Post-Conviction Relief Act petition back to the Pennsylvania Supreme Court as soon as possible. And I assure you, we're already putting our heads together on how to do this to make sure that we're identifying cases that can get this to the courts as soon as possible so that they can give a ruling on the retroactivity issue. I do feel confident that the court would hold that this was retroactive, but it is technically possible they could hold it's not retroactive. Why do I feel confident in that? Is because in this decision itself, in the Derek Lee case, they talked about the juvenile lifer cases, about Miller v. Alabama, and about Montgomery v. Louisiana, which was the case that held Miller retroactive. And in their discussion of those cases, they talked about the Miller v. Alabama holding protecting what they called a substantive right. And substantive rights in retroactivity law should apply and give relief to those who are serving otherwise unconstitutional sentences. But beyond the legal technicalities, I should go back. Quinn's been reminding me about this. I'm not always good at centering this, but this was not just a majority opinion of the Supreme Court. I mean, 5 people signed the majority opinion, but all 7 justices concurred in the outcome. It was a unanimous decision to strike down that sentence. And I, for one, think that this court will find that justice requires that if 1,000 people are serving an unconstitutional sentence, there must be a remedy for that. They're giving the legislature the opportunity to address it in the first instance. So that is an overview of the ruling and some of its implications, but I want to pass it to Quinn to address anything that I missed or any frequently asked questions we know that we are likely to get, because I couldn't have gotten everything, right, Quinn?
You did pretty well. Yeah, I don't have anything too specific, but just want to emphasize that there's a lot of open questions about how this will proceed in the coming months and years potentially. The next major push is obviously to hopefully get some legislation passed that will correct all of this. For some people, that still may mean that they need to be resentenced, and there might still be some litigation that needs to happen to apply this retroactively, depending on what's passed. But there are a lot of things that we just don't know at the moment. So we can't give you too much clarity on exactly how things will play out, but we'll do our best to answer any questions that we can, given what we do know.
And I will add one point, which is if there are resentencing proceedings because the legislature passes a law allowing these resentencings, or because they don't, and the courts say that resentencings have to happen, then I know a lot of people who are convicted of second-degree murder were also convicted of other charges in that case. And some people have been convicted of other charges after their incarceration. At a resentencing proceeding, a court is able to impose a new sentence for second-degree murder and decide that that runs concurrently to other convictions. So if people had consecutive sentences, sometimes called stack sentences, people have life without parole sentences, and then a 10 to 20 that's consecutive, and a 5 to 10 consecutive to that. That can all be reconsidered at a sentencing proceeding. And there are people who are resentenced after the juvenile lifer holdings that were able to have those run concurrently with other sentences that essentially wiped away a lot of time so that they could become parole eligible, and so many of them are home with us now. So I know that's something that people are wondering about specifically for their loved ones. So I wanted to kind of get ahead of that question and share that.
Okay, thank you, Brett and Quinn. So we're going to move into the legislative piece now. I know there's a lot of questions in the chat, and we hope to get to those, at the end of this. But we want to get through like all the information first. And right now, we're going to talk about what's happening in the legislature. And I'm going to pass it to Celeste to speak first.
Thank you so much. Good evening, everyone. It's so good to see everyone's faces. Again, thank you so much to Brett and Quinn for arguing that case and preparing so well. So we're so excited about the legislative options. I want to say that looking at how many people are on this call in this room, and even people who probably tried to get on and couldn't because of the technical difficulties, we are so powerful together, and it has shown over the past decades, right, what we can do together. As Salim mentioned, this is definitely something that we've been working on for so long, and it is sometimes slow, but wow, what a win. So the legislature has what now, 114 days, hopefully, to actually consider remedies. Luckily, we actually have legislation that has been pending before both the Senate and the House for quite some time now. It's unfortunate, that we had to wait for the Supreme Court to say something, but now that they have, we are so excited to be able to work with our lawmakers, work alongside all of you, the folks inside, everybody who couldn't make it, to move this legislation forward. We had a press conference last week. Press is all over this. I know there is an upcoming House Judiciary Committee vote on the House bill. And so we are moving, the legislature is moving, and we are really, really excited about this. Again, without all of you, none of this would be possible. Without our friends inside, none of this would be possible. But we did this, right? We all did this together, and we can do so much more. So the next few months are going to be very busy for all of us. I know many of us, our phones have been ringing off the hook since the ruling, and I know myself and Sean and Roxanne and so many other people have been working alongside our bill sponsors, our Judiciary Committee members, their staff, and really trying to make sure we have a clear path forward with a solid bill, right? And so I want to thank, everybody who has been working on that. I really want to shout out Chairman Briggs, who has been a champion for this bill. His bill, HB 443, is an incredible vehicle which would allow people who are currently serving this unconstitutional sentence to seek relief, and going forward, it would change things. And we also have a Senate bill. The general idea is, 25 years is what these bills are requiring, right? Before parole eligibility. Right. And so this is not a get out of jail free card. So many folks are curious and worried about what this will do. And what we want to say is this is a common sense idea. As Brett said, this was a unanimous decision that this is wrong, right? And so if it's wrong today, it was wrong yesterday, and we need to really make sure that our lawmakers and our community members understand how important it is to seek and create a remedy that actually serves the purposes of decarceration, our communities, and public safety. So we're really, really excited to do that. I know we're going to be talking later. I think Sean is going to be talking about next steps, action steps. John's going to be talking about the things that we can do. Every single one of us has this incredible power to reach out to our lawmakers, tell somebody, right? Talk to your community members, your neighbors about the importance of this, and ask them to reach out to their lawmakers too. They need to hear from us. They need to hear why this is so important and why this is an historic opportunity to stand on the right side of justice. And I'm so excited to work alongside of you. So we're excited. Tomorrow starts Second Chance Month, Fair Chance Month. It's an exciting opportunity. I also want to shout out that we're going to be having great, hands-on next steps, hopefully some press opportunities, some things, opportunities to go and do lobbying meetings. And so I hope all of you really stay involved as we try to push the legislature to move a really good bill forward. Roxanne?
Yeah, thank you so much, Celeste. Like Celeste said, we have to be united in this. We have our work cut out for us. We have some momentum going right now, but we also need to be very clear that this is not going to be easy, right? Legislators, even with this Supreme Court decision, are not motivated to do this, right? So we got to bring our people power to the Capitol, right? And we really want to, we know that HB 443, maybe it's not a bill that everybody loves, but it's the bill that, that we believe it has a fair chance of like getting some momentum. And also it's the best bill that we have right now in the General Assembly. And we really want people to get behind this bill and push it, right? And this is the best chance that we have. Some people might be asking, like, why 25 years, right? That seems like so many years, right? And it is like, we don't want to diminish that. We know 25 years is a long time to serve, especially if someone is not, you know, didn't like kill anybody, right? And so there's several, reasons why 25 is the number, right? We have to be take into account what our current landscape is right now in Harrisburg. We have divided government. We have a Democratic-led House, and we have a Republican-led Senate. But even in the Democratic-led House, we have Democrats that are hesitant to pass something like this. And so it's very challenging to do even 25 years. We'd be extremely lucky to get 25 years, right? And so that's why we need as many people pushing the legislator as possible to pass this bill. Another reason why 25 is that we have challenges with the current sentencing structure in Pennsylvania. So right now, the juvenile sentence for second degree is 30 years. And so even in this bill, we are lowering those numbers by 10 years. So like we lowered that number to 20 and for juveniles under 15 to 15 years in order for us to get to 25 years for adults. And so that is also a challenge that we are facing. And thirdly is the sentence for third degree. So the max sentence for third degree is 20 to 40 years. And so it's just not realistic to think that the General Assembly would pass a law for second degree that would have less time served than third degree. It's just not going to happen. So, we have to take all of these things into account, the landscape of, Harrisburg and what we're dealing with, and also what the current sentencing structure is. Like, we did not have a choice in that, and we're trying to work with it, but it's also, has limitations in what we can do. And so, I think, HB 443 is a really good bill. And we really want to get it passed, and we really want to be united when we come to Harrisburg. And I'll pass it to Wispy for anything additional.
Absolutely. And I just want to underscore, we fought for this bill. We have teed this up as the vehicle that we can achieve meaningful reform on this issue. And I want to kind of ground us just to go back a little bit to what Salim was saying earlier, right? This is a struggle that has a lot of chapters. And we saw that chapter with the juvenile lifers. We saw the chapter with increased commutations. And now we have this chapter. This chapter is struggle that we can commit to and complete together. And that once we finish this, we're not going to stop there. We're going to keep going further, right? We're going to make sure that first degree, people that have first degree, people that are geriatric have a pathway home. And one day, when we build enough power, in many, probably in many years to come, and when there's a better political landscape, we'll change the sentencing structure. But right now we have to focus on what is in front of us. And Roxanne gave us a very grounded analysis of the things that, we're up against. But, the thing I want to tell y'all is that we dealt with something kind of similar with the gatekeepers in Harrisburg last year, right? We passed a compassionate release bill out of the House. It's now in the Senate. And, we were told for the better part of last year that, we just couldn't do this. We had to do something, more, go back to the drawing board, do something more moderate, less expansive. And we kept moving forward on this. And, the thing is that together we can be powerful and we can actually outmaneuver the gatekeepers in Harrisburg. We were able to do that on 150, and we were able to pass that out of the House with a wide margin. But it's going to take all of us, right? It can't just be me, Celeste, Roxanne, Salim, a handful of others that are going to talk to these politicians. We need everybody tomorrow to reach out to their local state representative, to reach out to their state senator, right? And to promote these bills, HB 443, SB 387. And that is how we're going to do this. That's a first step. But the next step is that we're going to need y'all to come to Harrisburg some days. We're going to need to set up in-person meetings with legislators. We're going to need to talk to the media. We are going to need to get our faith, communities involved. We're going to need to get our unions involved. We're going to need to get our community organizations, ethnic associations we might belong to. Everybody we can bring to the table to bring pressure to bear on the political class that wants to sit on their hands, even though over 1,000 people are serving an unconstitutional sentence. We have to outmaneuver them to get this across the line. And when we do that and complete this chapter, you better believe there's a next chapter that's waiting for all of us to write to make sure that we get to that point when there is justice and a second look very early on in sentencings. But we got to face the situation that we got now, and we need all y'all to do it. So with that, I think we can, pass it back to Roxanne and we can move along. But I'm
Yeah.
glad to be in the struggle with y'all.
Yeah, John Rowland, is your camera on?
That's a lot of people, man. It sure
I'm
is.
trying to find John Rowland to spotlight him. John, can you talk so I can see you? Oh, there you are. Thank you.
Yeah. Hey, y'all. So we heard a little bit about the general ways that the general landscape of what's happening now. I'm going to tell you guys about what we all can do individually, collectively, and also kind of go through some of the larger things as well. So give me just a second.
We will be taking questions at the end, so I know you
Yeah.
guys, yeah.
I've also been monitoring the chat the whole time, so I know there's some outstanding questions. Gonna try to like work out some of the answers as we're going through the next steps. But also I'm gonna explain all these things, but everybody got this link because you signed up for some kind of registration link at some point. So just know we're gonna send this all out to everybody. You don't have to grab it right now. You don't have to fill it out right now. You can if you want to, by all means, go ahead and get signed up for it. But also if you want to, kind of just listen and take it all in, know that it will come to you many different ways. Also, lots of y'all have my number from, when inside the prisons, it'll be there again, and have other ways to contact all of us. That is one thing that I will say, though. If people did just get this link randomly, say a friend or family member sent it to you, make sure that you do sign up for one of these things so that we have you on some kind of list so that we can keep in touch, both so that we can take this collective action together, but also so that you're aware of everything. We'll keep people up to date with sessions like these, because like we heard at the start, from Brett, there's the ruling that basically all second-degree sentences are unconstitutional, but then we do have this weird 120-day period, right? And that's just going to be a flurry. It's going to be a new situation every week, basically, over these 120 days. So luckily, we do have people like Celeste, Roxanne, Wispy that are in the legislature all the time. They can keep us up to date with that. But also, it does mean there's a lot of info to keep everybody up with. And the things we're doing and the things we need to know will change week to week. So yeah, for these first 120 days, we have a few things, and a lot of this has already been dropped, but I just, again, want to lay it all out at once, and I'll put things in the chat as we go. There's a really easy thing that anybody can do, and this is also something you can share out with anybody, ask as a favor for it. And this is through Celeste's org FAMM. So just go, and again, we'll put all this stuff out for y'all later. To click this link, and it basically gives you a quick template to immediately send, letters, emails to your legislator, to support this bill. A lot of them are going to kind of know about it, maybe, but they're busy. There's a million other issues. So this does help to get it on their radar, to let them know that people are really interested in this. And even if you think your legislator might already support it, it doesn't hurt to do that. It doesn't hurt to kind of make it a more important issue for them. And one of the big things about this is, as Wispy and Roxanne and Celeste mentioned, this is not going to be a popular issue. There's going to be a lot of people that don't want to hear about it, don't want to talk about it, right? It's controversial. It doesn't necessarily help them politically. So we do need to keep up that pressure and make it be something that, they are taking seriously, and understanding that a lot of people do care about it. The second thing directly about the legislature that people can do is, like Salim mentioned, a lot of us have been doing this for a very long time. For people that are here for the first time, maybe this is your first meeting talking about, prison change, prison reform type stuff, sentencing reform, welcome, welcome. for everybody else, I see people in this room who have been at this for 50 years, literally even longer. So one of the things we did develop over this time is we have a kind of mass lobbying group called the Free Our People Coalition that's made up of people who were part of CADB, the grassroots group made up mostly of family members of people doing life, made up of people from Let's Get Free, people from Abolitionist Law Center. And that group is dedicated to going on as many legislative visits basically as possible to make sure the legislature is aware of these issues constantly. So I dropped just up there a link to join into that. Drop it again. So they're popping in the chat, which I love to see. But yeah, you just sign up there and you won't just be thrown directly into meetings by yourself or anything. We team you up with people, give you a little bit of training. We'll also do a training pretty soon about how to talk about this issue, how to talk to people. Yeah. Yes, the links will be emailed many different ways, and we'll put it out many different ways. And that's something we have done many visits, hundreds of visits over the last couple of years. But again, this is 120 days to really do this blitz. So we want as many people doing that as possible. So please sign up for that. Also, for all these things, you're not committing to doing anything just by signing up for now. You're not committing 20 hours a week or anything like that. If you're at all interested, the worst that happens is you're on an email list that you can get off of whenever you want to. So if you're at all interested, go ahead and sign up for that.
Can I ask a question?
We're
Hi.
going to do questions and answers.
We're gonna take questions at the end. Yeah.
Yeah, just in a second.
So please put it in the chat so that we can talk through that.
Yeah, just my thing kept kicking out.
So the next thing that's and also if you do click on the Free Our People thing, we're going to have a legislative training on April 21st, just so folks know about that. And that'll be about the time where I think we're going to start a bunch of lobbying. And that is because just the week before that, on April 15th, drop the link in for that. That is going to be our first mobilization where we're going to try to get as many people to come to Harrisburg as possible. To do what we have to do for this 120 days, just really make this an issue that everybody's hearing about all over the place, that is physically present in Harrisburg, that we're going on tons of visits for, that we're getting out to the press. And this is also a way, if we bring a bunch of people there, it helps to put pressure on our legislative allies, to take further steps on it, or for some of the people that are fence sitting, who are sort of like, I'm supposed to be good on this issue, but it might cost me a little politically, just to try to get them to commit. So there'll be a bunch of us that come by for that. But that's something we would really love for as many people as possible to come out to really set off this 120-day blitz. The other quick thing to do that everybody can do is, many of you already know about this group, many of you are part of this group, but the grassroots group, CADB, Coalition to Abolish Death by Incarceration, it's been going for many years now, over 10 years. That's an especially good place for family members to find other support, and other people who are like them going through this, and also to take action and to plug into all these things that are going on and other things. CADB meets, I'll drop this here, in Philadelphia. We meet in person and online at the same time, the third Wednesday of the month. So the next meeting will be in 3 weeks. And CADB has a chapter in Pittsburgh, or its own group in Pittsburgh, called CADB West for Western Pennsylvania. And they're actually meeting tomorrow night. So if folks are interested in that, you can email that link that's in there. And again, we'll also email all these things out to everybody.
All right.
And just the last one here, this is kind of a catch-all for everything. Like I mentioned, if people hadn't signed up, if we don't have your link in some way or other, if you just got this, please sign up to this thing. This is just a list that we're going to put together for everything that's going on. We'll let people know, right? If there's updates, we'll share that with this list. If there's different ways we can take action, we'll share that with this list. So that'll just be a general way of getting in touch with that.
All right. Thanks, John. I'm just going to add one thing in, but I want to highlight some of the things that John just said before I add that one kind of call to action in. The big things here are contact your state rep, your legislator. We're going to have links going out. John provided a really good way to get people plugged in to send emails through FAMM's link, right? We're going to do that. April 15th, we're going to have a bunch of people in Harrisburg do a big presser. We're going to have politicians there that support the issue, and we're going to put the others on notice, right? That they need to get right with this issue or there are going to be consequences. And we're going to get work to get this over the line. And the big thing that I wanted to add in here is that if you're part of an organization, organizations have a special role to play in this. Organizations can write stakeholder letters to the legislature, they can mobilize people, and we really want to hear from you if you represent an organization that can get involved in this struggle. So I'm going to put my email in the chat. We have a toolkit that we have developed specifically for organizations, for faith groups, for community organizations, for criminal justice reform organizations, for unions, etc., to get involved and to leverage their power in the situation. So I'm going to put my email in the chat. People can reach out to me, and we'll also have that going out in the follow-up email that we send to all y'all. But, be on point with what John laid out. Those are really powerful ways to take action.
Okay, now we are gonna do the Q&A. So
Hey, I got a quick,
Muti, we're gonna John.
who
Yeah,
the fuck?
yeah. Yeah, John, I'm gonna pass it to you for the Q&A.
Yeah. And we know this is just a short hour that we have together, and we started late. There's going to be a lot of other questions, going to be a lot of things that we won't be able to get to. But just wanted to go over some of the main things that people have put in the chat and some questions that we know are really relevant. But yeah, everybody is in touch with us and with other people here. And this is going to be a long follow-up to things. So I apologize if we don't get to every question, but please know that many of us really, really do want to make sure that those questions get answered. And we know this is a lot of information all coming at once and that people are really hungry for it. So we want to feed that as much as possible. So just to go over a couple of big questions, and I'm going to send these over to different people too, especially if they're more complicated questions. But just one thing, one general thing. Does the ruling apply to everybody who has second degree? Hopefully everybody has a good sense of that from what people have said. But it is a little bit complicated in the sense that, yes, the ruling applies to everybody. Let me kick it over to Brett for the subtleties of that.
Yeah, I mean, not to sound like a lawyer who wants to have it both ways, but it depends on what you mean by applies. So it does state that all who are sentenced to mandatory life without parole for the crime of second-degree murder are subject to an unconstitutional sentence. But they did not say whether it applies retroactively. And this is the sort of thing that courts in the United States, especially the US Supreme Court, has created, this distinction between a retroactive right or a non-retroactive right to really to limit constitutional rights. So if a case has already been decided and somebody's serving the sentence and there's a change in the law from the US or PA Supreme Court that maybe affected whether the police properly gathered evidence or how jury selection went or any other aspect of a criminal trial, the courts will determine, okay, we might want to issue a new ruling here with a new right, but they don't want people that had cases 10 years ago to be able to start relitigating those cases based on this new right. So that's where you have this distinction between what's retroactive and what's not. What rights do the courts decide apply retroactively? Rights that invalidate or make illegal a criminal sentence have been held to apply retroactively. And for the US Supreme Court, this has involved the death penalty in a number of instances where it has been struck down either because it involved, say, a certain criminal offense, like a non-homicide offense, that the death penalty was held to not be permissible as a punishment for, or when applied to certain people, like those with intellectual disability or those who were children. And then when the court struck down mandatory life without parole, there was a big fight for juveniles. When the Supreme Court struck that down for juveniles, there was a big fight as to whether that applied retroactively. And on the other side of the fight, the District Attorneys Association in Pennsylvania and the Pennsylvania Supreme Court at that time said that that doesn't apply retroactively because the court just struck down the mandatory nature of it. So that just requires a different procedure. It's not a substantive right. Life without parole is still permissible. So that's what the PA Supreme Court decided after Miller v. Alabama in 2013. The U.S. Supreme Court weighed in 2016 and said that is incorrect. This is a substantive right. The process of an individualized sentence that allows a life without parole, a life with parole sentence as an option is necessary to protect the substantive right to be free from an excessive punishment. So the ruling states that the statutory scheme or the penalty that's on the books for second-degree murder in Pennsylvania, which is mandatory life without parole, is unconstitutional. But unless the legislature passes a bill that applies to old cases, the court will have to make a different ruling that says the Derek Lee decision applies retroactively. If this is hard to follow, that's because courts are often, I would say, deliberately difficult to follow. But it essentially means they will address that later. It doesn't mean that it's not retroactive, and we're very confident that it will apply retroactively. But it is definitely the case that if the legislature passes a favorable bill, that would be the quicker way to get relief to people.
Thanks. And just want to move on quickly to the next question. Which actually just came up in the chat again. What is the name of the bill that we're pushing for now in these 120 days?
HB 443.
And what's the basic?
So it does two things. So like, wait, is somebody, yeah, HB 443. So it does a couple things. So retroactively, it allows, people who are sentenced as adults to be considered in front of the parole board after 25 years. And then prospectively, it's actually has a maximum sentencing range of 25 to 50 years. And so what that means prospectively, like anyone who's convicted after the bill would potentially be passed, is that that's the max sentence they could receive. Someone could receive a 10 to 20 or a 5 to 10. It would give judges discretion to decide what the sentence is, basically. And but for everyone who has loved ones inside who were sentenced as adults, they would have parole eligibility after 25 years.
And another legislative question. After these 120 days are up, what might happen then?
I mean, I guess I feel like that's more of a legal question, but I think potentially legislate.
Yeah, I think Brett touched on it, but
Brett or Quinn, yeah.
Just to be clear, too, a reminder that the 120 days was explicitly in the ruling. It said to give the legislature this time to act, right? So that's why.
Yeah.
So the 120 days technically applies to Derek's case. On a day 121, we can move in the Court of Common Pleas to move forward on the resentencing proceeding. It doesn't mean he would be resentenced on day 121. It just means the case would get moving again and the lawyers would begin preparing for what would happen at that hearing, presentation of evidence and things of that nature. It also, but I mean, even before that, we are going to be thinking through what cases could get the retroactivity issue in front of the PA Supreme Court as soon as possible. We think there's a good chance that there might be a case that can even be filed before then, so it would be waiting. We don't know when the PA Supreme Court would want to be taking that up. But there's a lot of different things to explore, including finding somebody who's filing their first PCRA in this issue, so it's timely filed, and there's no other. I won't get into all the jurisdictional thing, but we'll be looking at multiple vehicles that can get this back to the PA Supreme Court as soon as possible, if need be, so that they will address the retroactivity question. And
Yeah.
we will be pressing them so they don't take 2 years to decide this
Yeah.
case, which is how long it took from the date they
Yeah.
took Derek's case.
Yeah, Brett, I think people are wondering whether they can file their petitions now and whether, yeah.
So that is something I know that Quinn and myself and other lawyers who practice in this area are going to be kind of discussing as to what the best advice is. Now, to file a post-conviction relief act petition, if it's more than a year after direct appeal, which for most people serving the sentence it is, that is what's known as an untimely petition, and you can only get back into court with some exceptions. One is if there's been a new constitutional right, but the statute, the PCRA requires that new constitutional right to have been held to apply retroactively by the PA or US Supreme Court. So if you file the petition now, the lower courts are probably going to say this hasn't been held to apply retroactively, so you got to appeal it up the chain. But we're going to be looking to really be able to provide guidance on when people should file, because it's not necessarily the case you should wait 100 days, 20 days to get that into court. We're going to be working with other lawyers to probably draft what would be some model petitions. But look, we also know that many people, including many people on this call, including people that taught me about the law, who were not law professors in the first instance, but they were people on the inside. They're not waiting around for lawyers. They're not waiting around for Quinn or me or others to do stuff. I mean, somebody sent us a petition over the weekend. I think this person is out already, like that they're already filing stuff in the court. So we know that is going to happen. And we're going to do everything we can to provide consistent, reliable legal advice while also strategically thinking what are the best ways to get a case up to the PA Supreme Court as soon as possible to decide retroactivity in case the legislature sticks to its spineless ways.
Also, let me interject too about this PCRA thing. As someone who's been in there and already talking to people in there, the short answer to that is it's too early for us to have conclusive determination of what you should do when it comes to the PCRA. Stay updated. We will do our best to update you on that. But as we already know, our loved ones on the other side are already moving on this, and what we will do is try and make sure that we give you the accurate information so that whatever decisions they make, whether they decided to do it tomorrow or 60 days from a decision, that they have all the information in front of them to make the right decision.
Yep. And I just want to add to, there's no great rush on this. We have this 120-day window with the legislature, that we know nothing is going to happen with the courts in those 120 days. And then from whenever a decision is made about whether it's retroactive, people have a year to file something. There's a lot of things in motion. As terrible as the DOC is, for our loved ones in a lot of ways, they were pretty on top of making sure that people were aware if they could get back into court, after the Miller and Montgomery decisions with the juvenile lifers. So there's no great rush to get something into the courts right now. But like Brett and Salim said, we're going to be looking through all the options and figuring out the best guidance to give to people in the coming days and weeks.
I will also say that there will undoubtedly be a lot of people with interesting, innovative, and not reliable legal analyses and strategies. Those will be circulating as well. You can reach out to us. Many of you have my email. You can hit me up if you have questions about information that you're getting, right? So I'll do my best to
What's up,
respond
man?
to Quinn and others, but we know how certain ideas can circulate and they can give people false hopes, or they can make people think that they need to take this or that particular action, or that there's a certain thing that they can do that's going to provide more relief than is possible, or that, sooner than is possible. So check with us. We're a resource for y'all.
Okay, another couple questions that have come up, important, maybe difficult questions here too. Multiple folks have mentioned having, loved ones who have innocence claims. And this is getting ahead of ourselves, as we've just heard here. This won't happen for 120 days, but should there get to a resentencing phase, this is something that people understandably want to be able to talk through with loved ones. So can someone address how an innocence claim, whether it's active now in the courts on active appeal or not, would conflict or not with a resentencing?
I think that's Brad or Quinn.
The last part, what would conflict if somebody has an appeal in the courts right now?
Specifically an innocence claim, yes.
Right. Well, if they have an appeal that's, in the Superior Court or the PA Supreme Court or the federal courts, those courts will have jurisdiction prior to a sentence being imposed. This is actually something that came up in the juvenile lifer sentencing, and it can be a real challenge. There's people that could have been resentenced and been paroled, but it would have required, foregoing their challenges to the conviction. This is the sort of thing that I'd want to be talking about with the Innocence Project and some of our other partners who have more experience with those particular cases. But generally speaking, if there is an appeal and the court case is no longer within the trial court, the Court of Common Pleas, then the Court of Common Pleas will not have jurisdiction to rule on the resentencing issue until that other appeal is complete, and then they consider the next appeal that would be based on the sentence.
Great. And one more difficult question that was touched on a little bit, but a few people responded to it. Brett, you mentioned earlier that people could still get a DBI sentence in a theoretical resentence, and folks asked for some follow-up on that.
Yeah, so they just struck down the mandatory nature of the sentence. Life without parole is constitutional for second-degree murder. Life with parole must be an option, though, for the sentencing framework to be constitutional. The court did not give any guidance as to when a life without parole sentence would be appropriate. Now, in the juvenile lifer cases, the U.S. Supreme Court did give more guidance. They said if the crime reflects what they called transient immaturity, so basically impermanent passing immaturity, which, as we all know in the real world, anybody that's younger than 18, you are changing. You are still a child. The U.S. Supreme Court should have struck down life without parole for all children, but I think the politics of it were that they would permit that as a sentence, but they at least provided some factors for the court to consider around a person's youth, whether they were exposed to adverse influences from, peers or whatever else was going on in their life or in their community, experiences of trauma, etc. They didn't do that in the felony murder case, and I think there's some reasons for that, which is that aside from assessing somebody's involvement in the offense, you're not dealing with somebody's individual characteristics that are age related, but the courts also could not say if there were certain facts in the case, right? Like if somebody took somebody's life but was convicted of second-degree murder, then they get life without parole, because that would mean the sentencing courts would have to be determining certain facts. Did somebody commit the act that led to somebody's loss of life? And if you have to prove a certain fact in order to impose a punishment, then that means somebody would then basically the courts would be rewriting the law, which they can't do because they're not the legislature. They can say this law in the sentence for second-degree murder is unconstitutional. They can't say sentencing courts, if you find this or these other two things, you can impose life without parole, because that would be overstepping their bounds as a court. They can't rewrite the statutes, right? Just like the legislature also can't say retroactively, if there's cases where somebody was the shooter, somebody took somebody's life or somebody acted with recklessness to human life, then you can impose life without parole, because again, that would be creating a new fact that would have to be proven to impose life without parole. And you cannot create new facts that must be proven to sentence somebody after the commission of the crime. So if people are resentenced, they can only be resentenced based on the felony murder statute that was on the books at the time that the incident occurred. So I hope that's not too kind of technical here. But yeah, Celeste.
Quickly, I just want to also clarify that in the legislation that we have proposed, if the legislature does choose to act in the next, 115 days or so, life without parole is not an option for a sentence.
Yeah.
And so, yes, and right, I think it really, and all of us are kind of trying to figure out exactly what that's going to look like. But in the legislation that we do have proposed, life without parole is not an option for a sentence. So, yes, but hopefully no, if that makes sense.
Yeah. Which is another reason why the legislative reform, and in addition to it happening sooner than having to get the retroactivity issue decided, most likely, is we I think at the beginning, Celeste said, fortunately or luckily, Celeste or Roxanne, we have legislation, but there wasn't luck about it. This has been plotted for a long time and we've been prepared. So when this decision comes down, our movement are the ones with a plan, with a bill, ready to act on it. And it is one that takes life without parole off the table and provides a pathway home for everybody. Courts will tend to be more cautious.
Yeah, thanks, y'all. I also just want to validate what people are saying, that this is it's confusing and a lot of this isn't straightforward, right? And I think just to lift back up the fact that, these are complicated institutions that aren't designed to deliver justice or fairness, right? They're designed to have these sort of confusing loopholes and other things that are the way that things are actually governed. So what's happening in this situation is not that we have a very clear path to everybody's getting out tomorrow. It's that there are these sort of openings that have happened that didn't exist before in different institutions. And what we need to do, what we have to do, is just try to fill them as quickly as possible and try to take advantage of those openings that are there, right? But also be aware that these openings didn't exist last week, right? This is a major thing to be breaking through some of these barriers and knocking out some of these bricks from the wall, even if there's a lot more to do. And yeah, I do want to just validate that even for, everybody that does this every day, this is a frustrating situation. And it is a complicated situation. But also, it is it's a hopeful situation in ways that it hasn't been for quite a while for these 1,000+ people who we care deeply about. Since we're already
Hold on, John. Joyce Starr asked a question in the chat about attorneys. What will happen with attorneys? Starr, we don't that if this goes through the courts, we're going to assume that just like the juvenile lifer resentencing, that the counties would have to be responsible for appointing attorneys, but we don't have all that figured out yet. But just wanted to give you a heads up. We saw your question in the chat. And also, folks, you could also ask your questions in the chat and it will probably be responded to a lot quicker too as well.
And a quick follow-up on that question too, since a couple people asked it. Should anybody be looking into lawyers now? A bunch of people asked that via text and other things.
I will say that I would be very cautious of lawyers that are trying to take your money now to represent your loved one in a resentencing proceeding that doesn't exist yet, right? But what Celine was saying, like how the counties would take care of this, if there's a law that requires resentencing, or if the courts hold this applies retroactively and there's resentencing, everybody has a constitutional right to an attorney when they are being resentenced. So they will absolutely have that right and they will have legal counsel if there are to be resentencings.
And Kim, I see your questions. There's like 1,100 to 1,300 possibly people with felony murder in PA who will be impacted by this. However, there's 5,000 serving first-degree murder. So I just want to make that distinction for some folks. And I saw your question, Kim, in the chat. So I hope that answers your question. So total right now, there's almost 6,000 people, actually like 5,700 serving death by incarceration in Pennsylvania.
Yeah, that leads into another question that's important for all of us is, most of us who are in this room also know people that have first degree or that have another kind of a life sentence or a really long sentence. So just asking folks who are spotlighted to maybe give some perspective on how this ruling, we've said a few things about it, but how this ruling, might impact people who aren't directly impacted by it because it is strictly for people that have second degree. But yeah, for folks that are also serving DBI for first degree or serving other long sentences.
I mean, we've seen the door open before, right? And it's been kicked open, right, by people on this call. And we hope to continue to do that. These are, I think Sean said, chapters, right? Our movement is chapters, right? This is not the end. People on this call, we all love people who are serving sentences that aren't impacted by this ruling and by this legislation. We're not going to stop after that, right? I think it's something that we all need to work together to show. And this is what we have. We've got amazing representation of people who have come home through the juvenile lifer rulings, right? And then that was made retroactive. And now we have more people who are incredible examples. We have people who were able to come home through commutation that are incredible examples of people who should have already been home. And so utilizing these opportunities to show that we have incredible people who do come home and don't go back, right? That only helps us work, right, toward being able to help provide relief for everybody. So I would say help now because we're going to continue to work to help everybody. We just know our legislature is unfortunately not really excited about the idea of touching first degree right now, but that doesn't mean we're going to stop pressuring them to do so.
Yeah, I think with that, if Liz, if you can drop the links in the chat one more time. I know we didn't have a chance to get to everyone's questions, but we've gone quite a bit over, and I know it's been about an hour since we started now. But we will be available to answer any questions that people have. You can send us an email. We will be sending follow-up emails with all the links. Liz is also dropping them in the chat again, but I'm gonna pass it to Salim to close us out tonight.
Yeah, I'm not going to try and hold people up. Folks know what we got to do. We got to do what we always been doing. Fight, fight, fight. Thank y'all for joining us tonight. Sorry we couldn't get to everyone, but you have our information, and we will be reaching out to you for everyone who signed up, as well as we'll be sending out mass updates consistently, y'all. Have a good night, everybody. Thank you for joining us.
Good night, y'all.
Good to see you home.
Thank you. Thank you. Thank you.